Welcome back. My name is Philip Saunders, and I'll be moderating this afternoon's session. And in accordance with our quick introduction practice, our first speaker is John Cliff, QC, of the Vancouver firm Cliff Tobias, and he'll be speaking on creative sentencing in environmental prosecutions, the Canadian experience, an overview. So, turn it to you, John. Thanks.
Thanks, Phil. May I just open by thanking Martin and the other organizers of this conference for the opportunity to speak to you this afternoon. I'd also like to thank Nancy Money, who's the administrator of the program, for her patience and understanding, particularly with respect to my paper and my late filing of my paper. And in that regard, I've written a short paper to cover my topic, which is a broad one, and that is the Canadian experience with creative sentencing. As you all can see, I'm not using a PowerPoint, and instead I'm going to share my thoughts with you the old-fashioned way. Let me say this, that my thoughts and comments here are from a practitioner's perspective, and of course in the criminal context. And I do apologize if for some reason I do become somewhat blunt with my views and thoughts. As a bit of a basic premise, I think it's fair to say that in the criminal law context generally, the sentence hearing is the most important part of the process. And I would respectfully submit the same is true in the case of environmental prosecutions. And what is regrettable is many times both the Crown and the defense don't think of sentence until after there's been a finding of guilt. And that's a natural progression in the sense that in the case of the Crown, you're concerned with charge approval, you're concerned about preparing for trial, you're concerned about things like disclosure, other applications that are collateral to the trial process, and so on, and hence a sentence becomes this afterthought. And if you're acting for the accused, you may be involved right from the stage of the investigation. You may be involved with the receiving of disclosure, taking instructions from your client, and appreciating the case. And as you gear up and move towards that ultimate trial date, and as I say, sentence becomes this rather afterthought. And I recall learned counsel, defense counsel, in many of the early cases that Judge Stewart heard in the Yukon, and he also appeared in a number of cases in the Northwest Territories, David Searle, QC, who stressed that point, that counsel forget about sentence, and that should always be on your mind. Now that said, in my view, counsel have to be aware of the applicable legislation. That sounds rather trite, but you'd be surprised. What legislation is the accused charged under, and what's the availability of various sentence options? Are we talking about the true traditional sentence options? And there are still pieces, particularly of federal environmental legislation, where that's all there is, jail and a fine, notwithstanding the amendments that Rebecca told us about earlier this morning. So the question becomes, do the provisions contain creative sentence options? And in that regard, what do they allow for? And legislation, notwithstanding the EEA amendments or the EEA legislation, you see in the federal family still a kind of a hodgepodge of available options between pieces of legislation. So as a general comment, I say this, that the orders tend to be, as the legislation says, orders of direction, prohibition, and requirement. That is, court orders being the first creative sentence option. And then there are collateral options And that is, we heard about some of those, that is additional fines to capture benefit, permit and license violation, and forfeiture. And I stress that aspect of forfeiture of seized items because that sometimes occurs in environmental offenses, and that is, you can imagine the inspector or the fishery officer, the conservation officer, seeing the classic example of the Caterpillar tractor bulldozer in the creek and chooses to seize it. It could be subject to forfeiture upon conviction. One aspect you have to be mindful about regarding creative sentencing is just the statutory preconditions that go with it. You don't just jump to the court making a creative sentence. Invariably, the legislation is written in such a fashion that the court has got to focus on the circumstances of the particular offense for which the court is going to sentence upon. And invariably, the legislation is written that this option is in addition to any other penalty. So I say this, because we had such an informative presentation from Rebecca about the EEA legislation that impacts 9 pieces of federal legislation. The concern I have with respect to that is that dealing with the small revenue offender, small revenue corporate offender, that the minimum sentence may be such that it hampers or deters the sentencing court from actually imposing a creative sentence option in addition to that fine. That they're high enough where the court's going to say, I'm not going to go there. Now, I pause, and with respect to your consideration as counsel, with respect to the fact that obviously you're familiar with, or should be familiar with, the applicable common law principles of sentence and the statutory principles and factors of sentence. More and more, at least in the federal family of legislation, environmental legislation, you're seeing statutory factors of sentence being presented in the legislation for the court to consider. I also stress this in consideration of creative sentence. Look at past sentence cases, but don't get bound by them. I think it's fair to say that we get trapped in the environmental field or in the regulatory field of, particularly when you're acting for the Crown, with the defense having the 2 or 3 cases in the area and trying to convince the sentencing court, this is the way you should go, you should be bound by the precedents. And I'm really, I advocate that counsel have got to step away from that there is an opportunity to be creative, either for the defense or for the Crown, and not get stonewalled into using the few precedent cases that may be out there. So what is a creative sentence? In my view, I think that's an easy question to be answered, and that is any sentence other than one that is reflective of the traditional sentence options of a fine and jail. Something in addition to that. Where do you find it? You find it in the legislation under which the accused is charged. You find the opportunity to sentence creatively with respect to federal environmental offenses under the Criminal Code of Canada. And keep in mind that the code does have provisions with respect to corporate offenders, and most importantly, they have a basket condition. And what I mean by that is a very general condition that permits the court to consider a reasonable condition that ensures the good behavior of the offender and prevents a repetition of the offense. So there's lots of opportunity in the federal side, and I would also say on the provincial side, given various provincial and territorial offense acts and the specific environmental legislation under which an accused can be charged provincially or territorially for a creative sentence to occur. So what are the various options? As I said earlier, specifically There are options with respect to prohibition, or what Judge Stewart was referring to earlier this morning, these stop and control orders. So there's prohibition, there's direction, and there's requirement. And I stress to you that the options vary between the statutes. As I say, in the federal field, you can go to the Northwest Territories Water Act, which is a very important piece of legislation protecting the many waters of the Northwest Territories, to a traditional sentence, and penalty provisions that have remained unchanged for some time, to detailed schemes such as SEPA. As I said earlier, there's the additional collateral legislation to capture benefit. There's revocation of licenses and forfeiture. I want to stress one aspect about probation orders. I've used corporate probation under the criminal code in other federal regulatory statutes. And one section that I really like to use, or not so much I like to use, one of the features that I like about corporate probation is the fact that the statutory terms and conditions of a criminal code order apply. And one of them is keeping the peace and being of good behavior. And you can imagine what that does to a corporate offender. I mean, that's everything, as far as I'm concerned. And usually it is based upon a conviction being entered, although there's some case law that says it doesn't have to be. So it's keeping the corporate offender with the eye on the ball to, in fact, abide by all laws, not just the law under which they've been convicted. And as I say, there's this opportunity of a basket clause term, and you can be as creative as you want to be creative. Let me go back a little bit. As I say, I've written a paper. I've covered off some examples for you of creative sentencing. I've dealt with the best I can in my relatively brief paper with respect to the concept of creative sentencing, but just talk about what was in the past prior to these various provisions that we see in legislation today. And that is, I think we saw a lot of judicial creativity, in particular by our first speaker this morning, Judge Stewart, and also by his colleague at the same time working in the Northwest Territories, Judge Barassa, Judge Michelle Barassa of the Territorial Court of the Northwest Territories. Both of them were prolific in their judgments. Both of them were prolific in their application of these environmental laws in the northern setting. I'll say this, that we see these amendments to legislation starting in the late 1980s and moving to the current time. But prior to that, very few pieces of legislation allowed for this creative sentencing. And it didn't stop these judges from, in fact, being creative and from doing what some authors and even some judges have said, torturing the legislation to make a sentence work. That is, make the sentence go back to the environment. Make the environment be the recipient of the penalty that was imposed. And in particular, what Judge Barassa and Judge Stewart did was work with, in the case of Fisheries Act cases, which tend to be the more common prosecution at the time, to make offenders accountable for pollution of fish-bearing waters, was to work with Section 33, subsection 7, also known as 41, subsection 2 of the Act, which allowed the court a jurisdiction to take action upon conviction. And one of the interesting examples I've always thought of was Judge Stewart's decision in a case called Placer Developments. And what Judge Stewart did in that case was being upset at the way that the environmental investigators dealt with the accused, the corporate accused, and also, in fact, Crown Counsel, with all due respect, was imposed a fine of $1 under the Fisheries Act and then made an order under Section 33, Section 7, for the company to prepare for industry certain winter camp protection procedures. That is, many of these exploration camps are left over the winter in the north. There would be piping, there would be tanks and so on. So essentially it was a guidepost that they had to go meet with their experts and create a manual to be used by others in the mining exploration industry. And talking to counsel in that case some years after the fact, Bob Ward from Vancouver, he just said, I don't know why I got roped into this, because at the end of the day I would have preferred to have my client fined. It cost so much money, and the effort was, according to him, unbelievable with respect to getting this thing completed, published, and circulated. So many times these orders, and I'll stress the point a little later, these orders, unless the statute says otherwise, are limitless in the amount of money that can be spent pursuant to the order. And the only exception that I know of is a provision in the Transportation of Dangerous Goods Act, federally, that allows for a cap of $1 million. Other pieces of legislation, and there's been some jurisprudence to that point, with a finding there is no limit. So you've got Stewart in Placer Developments. You have Judge Barassa in a case called Canadian Marine. Now, in Canadian Marine, he didn't impose an order under that previous provision of the Fisheries Act, but he made some very strong comments about the potential under that particular piece of legislation. And then in a case called Robinson's Trucking, he actually applied it. He said, no, in this case there'll be a fine, yes, but there's going to be procedures put in place by way of court order. There's to be organizational changes in the company and so on. Now, I'll tell you a little bit about my experience because it's perhaps my thinking, and I go back to the point I want to make. I'm a practitioner. I'm definitely not an academic, but I'm always alive to an interesting idea to put before the court. And my experience with creative sentencing was about 25 years ago in a case called Regina versus McMillan Blodell. It was a gas pipe at a mechanic shed operated by the corporate offender up in the Queen Charlotte Islands. The pipe breaks, gasoline goes into a creek and kills fish. And talking to defense counsel in the case, his view was, I think we should enter a plea. I haven't got a defense, so what is it that you're looking for? And I was initially thinking the standard for that time anyways, 25 years ago, something in the region of about $15,000, $20,000 as a financial penalty. And we both got talking, and being both cynical West Coast boys, why don't we keep this money away from Ottawa? Let's keep it away from the Consolidated Revenue Fund. Let's keep it in the community. And at the time, economic times in the small community of Queen Charlotte City were bad. Any kind of work was appreciated, and we crafted an order under Section 33, subsection 7, essentially to cover that off, get some people working, get them working on the creek to remediate it, some adjacent fish habitat, let them buy their equipment in the local stores, and so on. And it worked for everybody. It worked for the local fishery officers that investigated the case. It worked for the community, and it worked for the accused, and most importantly, it worked for the environment. So that was my taste of it, and I'm going to pause here and just say this, that ever since, my approach to, if it can be done, if it's appropriate, and most cases allow for some kind of creative thought and a creative sentencing option, most of the cases that I prosecuted when I was with the Federal Crown resolved themselves with a creative sentence. And how we did it, and I take it a different view than what Rebecca was saying about these minimum sentences. I'm an old-time prosecutor, and I just think that the court should have a considerable amount of discretion. I don't even like to have my discretion as a prosecutor in any way hampered with. And I mean, no disrespect to Rebecca. It is an initiative, and it is the law. But the way I kind of see creative sentencing is, in crafting that kind of sentence, it's always a consideration of some pretty obvious common sense group of factors. And one of them is the ability of that accused to comply with the order and to pay the money or spend the money. So I always look at, what is this offense worth from a fiscal point of view, as far as the principles of deterrence and the other applicable principles. And then I move to that to, is the creative sentence option available? And then do the break with respect to, well, a certain portion should be the fine to meet the statutory requirement of the creative sentence provision, and the balance being going in some form of creative order. So I kind of see the minimum sentencing kind of making that discretion of the prosecutor a little bit more difficult. But that said, let me say this, that I take the view that these current creative sentencing provisions, now that we have a true legislative roadmap here, being an effective scheme to get to that fit and proper sentence, because that's the goal. So why is it so? And I only say this in summary, I won't detail it. There's so many specific potential options that are specified in the legislation of the various kinds of prohibition, direction, and requirement. And most importantly, and invariably in these schemes are these basket clauses, these very general terms that the court can do just about anything it wants to do. So again, you have lots of flexibility, lots of opportunity to be creative with your learned friend. Usually these orders are in addition to other penalties, so there's other penalties to be imposed in the case, ensuring that the corporate offender or the offender is held responsible. The legislation allows for more than one option, so you're not just left with an order of a payment. You can have an order for a payment to the Crown for these very important environmental purposes. You can have a stop and control order like Judge Stewart was talking about. You can have a publication order. You can have numerous conditions in that creative sentence order. You're not bound to just one. As I say, there's the basket clause. There's no financial limit. And of course, many of these schemes have variation terms in them, that the orders can be varied upon application by one or both of the parties. They're enforceable. Non-compliance with these orders usually is an offense under the enabling legislation. And if it isn't, resort by the Crown to Section 126 of the Criminal Code, except in the case of an order to make a payment of money would be applicable. Now, there is a small growing body of precedent out there. We know that. In my paper at pages 7 and 8, I've listed some cases for your reference. I'll just give a couple of examples of cases. Many times, I'll just pause and say this, many times these cases, at least in my experience, maybe others have a different experience on the defense side or on the Crown side, resolve themselves. There might be the initial toing and froing that counsel do once charges are laid on behalf of their client and on behalf of the Crown, but for many reasons they resolve themselves with guilty pleas. And many times my experience is that you can usually resolve it with a joint sentence submission. So hence this opportunity to use the creative sentence options. Other cases, they're truly contested, and one of them that I dealt with is the case of Regina versus the city of Dawson in the Yukon. And we had a 3-day sentencing hearing. They decided to plead guilty. It was about a single incident of deposit of a deleterious substance being untreated sewage into the Yukon River from the city's sewage treatment plant. But it opened up the whole specter of the historical sewage problem that the city had right from its iconic beginnings in the Klondike. The problem of untreated sewage going into the river was truly problematic. So Environment Canada, who led the investigation, were adamant, we want an order, because we're having great difficulties of getting them to comply. We want an order for the city to construct and operate a sewage treatment plant whose effluent would meet the provisions of the Fisheries Act. Well, that sounded all rather interesting and so on, and I bought into it, and we had a lengthy hearing, and ultimately the sentencing judge agreed with it and made an order. And the interesting thing that as I reflect on it, I didn't realize what I had done to the judicial system up in the Yukon and the time we spent over the next 10 years trying to get the city of Dawson to comply with the order. It was interesting. There was all kinds of politics at all kinds of levels. Ultimately, they complied. But there was many a time, including a particular report back to court appearance, where I had that, I could stand on a soapbox and accuse the premier of the Yukon Territory. The conduct of the government is approaching contempt of court, is that they're refusing to comply with the order. But as I say, ultimately, it gets complied with. The second case, again, also contested, was a case against the Power Corporation in the Northwest Territories, and it was a case that caused considerable amount of actual environmental damage when a berm to a dam's reservoir was breached. And that case was more about an order that the Crown was seeking with respect to a large payment going to the federal government, and in particular to the Minister of Fisheries notions, to promote the protection and conservation of fish and fish habitat in the Northwest Territories. Again, a lengthy contested hearing, the calling of evidence, and I think we litigated that over a period of about 8 days. And the final example I'll share with you, just a recent case I prosecuted before I left the Crown, and that was the case of Regina versus Champion Shipping, which was a prosecution of ocean dumping under the Canadian Environmental Protection Act. And that resolved itself by way of a joint sentence submission. But again, looking at the monies not going to the Consolidated Revenue Fund in the form of a fine, but seeing the money go to a specific order. And in that particular case, the monies went to the study of the effect of marine pollutants upon seabirds, where the research was being done by the Faculty of Science at the University of Victoria. So it was going directly to the University of Victoria to fund that research. So you can be creative. The outreach here for me obviously was because I'm a prosecutor that in grade 11, which was too many years ago for me to remember, couldn't analyze the color of the Bunsen burner flame. The help of good experts, good technical folks to brief you, whether you're on the defense side or the Crown side, in coming up with and researching the appropriate creative sentencing option to be pursued and convincing the court to make that order. Let me say this as well. The concepts of creative sentence, in my mind, it sounds so good that you're going to do something other than that traditional sentencing option. And the way I see it, quite frankly, is that it really is, as much as it sounds good and looks good on paper, it's hard work, and it doesn't necessarily channel itself to that actual outcome where you look at these great options. Can I get there? Can I actually get to the kind of Cadillac creative sentence option? And regrettably, in my mind, you don't get there. It's hard to get there. And it's hard to get there that in the real life of criminal litigation in this particular field is that, from the Crown's point of view, and it's not a knock against the investigators. They do good jobs, good work with respect to relatively complex laws and how they gather the evidence. And I've got no knock about that. I put up a conservation officer or a renewable resources officer or a fishery officer up against a Royal Canadian Mounted Police officer in investigating these kinds of cases. They're good at it. But many times we don't get the whole story. They're complex cases. And once charges get laid, they've usually been vetted by Crown Counsel, so the consequence is there's a reasonable prospect of conviction. So ultimately becomes a question of litigation risk. You know, are we going to, the defense comes to you as the Crown and says, well, we'll plead, but this is where we want to see sentence go. And now this doesn't mean you roll over and play dead. Or for that matter, you as Crown Counsel go to the defense. What about a plea? You know, let's talk about this. Let's resolve this. I mean, I can share many sort of war stories, as Martin was asking me to do, but I'm not going to do that. But the bottom line is there's a reality sets in, and the reality is that maybe the Cadillac option is just not going to be there. So what options are there? I say this, that you can't forget, of course, that it's all coming out of the criminal context. You can't forget, like all sentences, it's discretionary. It's not mandatory. The judge has to be convinced that a creative sentence is the appropriate sentence in this case. Now, my experience has been that judges like these kinds of cases. They don't want to necessarily see the fines go to the Consolidated Revenue Fund or a provincial revenue fund. They want to see something going back to the environment. And it might very well be because many of these cases get resolved at the provincial and territorial courts level, that after seeing so many assaults and so many street drug trafficking cases and impaired drivers, they've got an interesting case sitting on their docket. And they want to write something or do something with it. So you got to keep in mind it is discretionary. We have the feature that it's in addition to any other punishment, so the judge may be wondering about whether they want to go that far to make that order. The court does have to consider the specific circumstances of the offense. So maybe asking for the Cadillac changes to the corporate's manufacturing processes is not applicable to the specific offense for which the accused has been convicted. So there's got to be focus on those circumstances. You can't forget, and I go back to Diane's point about fairness, that there's an obligation of the sentencing court, and counsel have to be aware of the fact that, and it is mandated by the criminal code, there is the principles of proportionality and parity. So the issue of fairness should be encompassed in those two principles. So the court's bound by that and has to impose that fit and proper sentence that reflects proportionality and parity. And of course must meet that paramount principle that we sometimes forget but should never, which is deterrence. So I'm going to leave you with a couple of tips from my experience dealing with these cases, and that is counsel should have sentence on their mind right from the time that charges are laid or your client gets a summons. I know that once I've gone back to the defense side of things, that my way of thinking has changed a little bit, but I keep sentence at the forefront. What happens if my client gets convicted? So keep that at the forefront. Keep at the forefront that availability of those creative sentence options. I say this to you that counsel and for the defense and the Crown should be asking those questions of your experts, your technical people, about creative sentence. What's available? What can be put before the court? You should research these options. And you can't forget proportionality and parity. You can't forget the circumstances. All have to be built into your decision making. Work towards a joint sentence submission if that's possible. Think about an agreed statement of facts to put before the court, and keep the communication going between the parties. The idea of an agreed sentence, a joint sentence submission and an agreed statement of facts, I think work for both parties, that is the Crown and the defense. There's a certain amount of litigation litigation risk is managed to the nth degree, always knowing that the sentencing judge is I don't want to say, I better be careful what I say here, but in any event, is the person who's going to be the ultimate decision maker. And the agreed statement of facts tells a story that should be accurate and candid, but the flip side of it is it can be managed. I did want to speak before Sharon comes down here to continue the discussion. Just to emphasize to you that my view is creative sentencing is the way to go. I think it's reflected in many of the cases that are coming out of the courts, although we're not seeing a lot of cases coming to the courts, but many of them are turning to the creative sentence option. As I say, I've given you many examples in my paper. I'll just briefly comment on, and I think there's another speaker that'll be talking about it, so I'll be very brief. There's some distant relatives to creative sentencing, and that is where counsel in a prosecution with a statute that does not permit creative sentencing have agreed that certain works and efforts that would have been the equivalent of a creative sentence are done after charges are laid, but before the accused enters his plea or its plea of guilty. And I've cited an example of a case under the Northwest Territories Water Act in a case called Regina versus Boart Longyear, which was a drilling company that was doing exploratory drilling for diamonds in the Northwest Territories, did damage to a small lake. They were charged under that legislation. It was either a fine or a jail time. At the time, the code hadn't been amended with respect to corporate probation, and we had them do works and efforts that were akin to creative sentencing, and then were sentenced after the fact, with that being taken into consideration by the sentencing judge. Rare, I admit. And finally, there is the issue, His Honor this morning talked about restorative justice. I don't know what the experience is in other parts of Canada, but we've had a couple of experiences in British Columbia where the Crown's essentially been left out of it, and rightly so, where there's been an investigation of an environmental incident, and the investigators and the suspect have gotten together and done what was called restorative justice, or an alternative measures agreement, keeping it out of court. Except the practice in British Columbia has been to deal with that all behind closed doors. There's no public transparency. And I know that my colleagues on the provincial side, my former colleagues on the provincial side, and my former colleagues on the federal side as prosecutors were opposed to that type of resolution, just for the sake that the public is not involved. So that's out there. There's a couple of pieces of legislation that permit that to happen on a more formal end of things, and that's the Canadian Environmental Protection Act with its so-called EPAM process, or Environmental Protection Alternative Measures, and also the Species at Risk has a similar type of scheme with it. And with that, those are my comments.
Thank you very much. I understand we need a couple of minutes to sort out the audio. Well, will the questions be broadcast? I guess it's...
It sounds like it's just a few people that are having issues, so.
Just a few people? So just go ahead. Okay, we'll go ahead. So I'll ask if anybody's forward any questions. We'll have those come down. But, okay, we'll start here.
I hope there's not a lot of them, Phil.
We won't have it for a lot. The second binder is coming down.
Yeah, no, thank you.
With Mitt Romney, binders and binders of questions. In your view and experience, are environmental sentences generally within the right range, or would you agree, at least with the ethos behind the EEA, that fines, including dollars towards creative sentencing, are too low?
Yeah, I would say, well, I mean, obviously, every case is going to depend upon its own circumstances. I suppose if you looked at it broadly, one view is fines or financial penalties. I'll call them financial penalties, being both the inclusion of fines and creative sentence orders should be higher. But I'm seeing at least a few cases where we're seeing a bit of an increase in the common law without the benefit of the EEA. That said, if all we're talking about is measuring in fines only, and that's a little bit different than the views that we're hearing from Judge Stewart. And what we want to do, and that is for the various reasons why he stated earlier why there should be other forms of penalty here, other ways to get compliance, other ways to find the offender responsible. I just see it as being, in one breath, yes, financial penalties should be higher. Second breath, I don't like the idea of a minimum sentence because it does, I think, deter the prosecutor from acting in a certain way, and also it puts a hamper on that trial judge as well.
The next one, and I think this probably applies in a couple of sessions. What implications would creative sentencing hold for the role of the courts in monitoring? Will this expanded role require significant new resources on the part of the courts?
Well, I think that if the case that I dealt with, the City of Dawson case, is an example of a case going wrong. And I don't think it could go any more wrong than what happened in that case, where the offender just plainly was refusing to comply with the order. And we didn't want to go after the city and prosecute them again. We were prepared to cut them a lot of slack to get the appropriate funding, get the proper planning, and actually comply with that order. And it was a major capital project. So going back to the question, which is, well, is there going to be more, in the case of the recalcitrant, non-complying offender? Yes, the court's going to have to spend some more resources. But there are so few cases that come to the court, I don't see this being a particularly noticeable strain, assuming the unusual situation of the non-compliant offender.
Okay. The next one, dealing with the situation of creative sentences for environmental remediation cases, or actual remediation work. This seems highly dependent on getting a lot right, scientifically, and economic, and the social impacts. Is there a concern that a sentencing hearing in an overstressed court with overworked crowns might not be the best place to make the assessment of whether the planned work will actually have the desired outcome?
At first blush, I'd agree with that 100%.
Yes,
I agree with that, absolutely. But given that this topic is about creative sentencing in that criminal context, and assuming that the case has not gone to the situation that our colleague earlier today was discussing about an administrative remedy of some sort, if it's ended up in the criminal courts and we're prosecuting, that's just going to have to be the way that case is unfolded, or is going to unfold. It's going to be a lengthy sentencing hearing, and if it is a matter of a couple of weeks, that's just the way it's going to have to be. Now, I can only speak for British Columbia, and I know of Ontario, but there are dedicated environmental prosecutors in both those jurisdictions. I would expect that in the other parts of Canada, the Crown agencies have those prosecutors that are dedicated to specifically dealing with those kinds of cases. So I don't see that necessarily a problem. Court time, yes. But again, so few cases get to the courts. I don't see it as being this avalanche of a problem that the questioner is asking.
Okay, I think we have time for a couple more. One, do you anticipate significantly greater use of creative sentencing with the introduction of the new EEA provisions?
Well, I would hope so. I would hope that I mean, like philosophically, my view is that's the way sentencing should be in these types of regulatory cases. The EEA, I have that reservation that I expressed earlier in my submission to you all, but the idea that the EEA, at least with respect to the 9 pieces of legislation that it's amending, is pushing the creative sentencing option. I'd like to think that we're going to see more of those sentences.
Okay, and one final short one. Even beyond any statutory preconditions, is it fair to assume that achieving creative options will be unlikely in anything other than an agreed or negotiated process, unless you have that rare judge who's willing to strike out on their own without agreement of the parties?
Well, I gave 2 examples of cases where, and I'm certain that there's a former colleague of mine on the provincial side I'm sitting next to, Jim McCauley from the province of British Columbia, what his experience is. But I've dealt with contested cases where the Crown is seeking a creative sentence and the defense is not. And so the way I kind of see it is that you can still work outside of that agreed sentence model, but I just say this, as I said earlier in my address to you, it may very well be that the realities of the case, notwithstanding what we think happened, notwithstanding how we think that was so bad or we needed to change the procedures, if we can't prove it, then the chances of litigating that in a contested sentencing hearing are going to be rare.
Great. Thank you very much. I'd like to thank John for